So I will try to be short, Federica, although I have to admit that it's not easy because it's a very interesting and rich and full of knowledge from both practitioners and scholars book. This is a volume that I'm co-editing together with my colleagues Federica Casarosa and Mohor Pashtiga. And as you can see from the title, his main focus is freedom of expression of judges from two perspectives, both the supranational, so the perspective of supranational courts, the European Court of Human Rights and the European Court of Justice, but also from selected national jurisdictions. And what I think it's different about this volume is that it does not simply include an academic debate, but it's actually based on discussions, debate between scholars and practitioners going through to almost 2 years, which was the time span of the previous trial project. So we tried in these chapters to actually concise all the information that we have gathered in 2 years. So the purpose of my presentation would be just to shortly introduce the context of the book, the leading research questions and objectives, and then just go a little bit through the structure and the key findings. So the main aim of the book is to explore the complex relation between freedom of expression of judges and judicial independence in light of the rule of law challenges. And why I say complex is that we have, until the rule of law crisis, freedom of expression of judges was approached with cautiousness, in the sense that judges were asked mostly from their national council judiciaries or ministries of interior, including presidents of courts, to show restraint and should avoid to speak directly with media unless they had a role of spokesperson of court. Also, they were asked to not debate the content of their judgments or also the judgments of their colleagues. And the rule of law crisis has actually triggered a paradigm shift in how we perceive freedom of expression of judges, because we saw a change from approaching freedom of expression from the perspective of a duty of restraint to balancing this with an actual moral duty to speak out. And we have this duty coming out already in earlier judgment, let's say earlier than the rule of law crisis, that is back in Hungary, which was at the beginning, and then later on it was re-emphasized in Covesi versus Romania. These two judgments, of course, were focusing on judges that had a particular managerial function. So Baca, I think he was the president of the Supreme Court. In Covesi, she was the chief prosecutor for also corruption. So because of their high representational role, they had also this moral duty to speak about judicial reforms that were raising issues regarding judicial independence. However, this moral duty extended in later jurisprudence not only to judges having these particular high functions, but to all judges involved so part of the judiciary. And this is said clearly by the European Court of Human Rights in the Zurich judgment. The court said the general right to freedom of expression of judges to address matters concerning the functioning of the justice system may be transformed into a corresponding duty to speak out in the defense of the rule of law and judicial independence when those fundamental values come under threat. So we see slowly, with the unfolding of the rule of law crisis, the change in the conceptualization of freedom of expression of judges. And another facet of the freedom of expression was this part that, because it was earlier perceived as requiring also a duty of restraint, certain exercises of freedom of expression that were not falling within the accepted definition within national codes of ethics would trigger disciplinary sanctions. However, within the framework of the rule of law crisis, this conceptualization started to be abused, and we saw in jurisprudence, again, from the European Court of Human Rights and the Court of Justice of the EU, that judges, especially the independent-minded, let's say, were starting to be disciplined for the way they were expressing their freedom of expression in the form of commenting or addressing issues in judicial reform. And another change within this wider context that we are addressing in the edited book is that for a long time, the European Court of Human Rights was the main stakeholder in setting the key guidelines on freedom of expression of judges. Whereas within the rule of law crisis, we saw another actor defining standards and rules on freedom of expression of judges, that is the Court of Justice of the EU, but from a very different perspective. And this has also been very clearly highlighted by Mohor in the booklet. He has a quite eloquent and clear paragraph on how actually the Court of Justice is looking at the freedom of expression of judges as a facet of judicial independence, and as part, actually, as a manifestation of the national court's rights to send preliminary reference procedures. So this is a little bit about the context, and now I will go a little bit to another key change, that is the jurisprudence, the growing jurisprudence of the Court of Justice on the rule of law crisis, which, although has not focused primarily on freedom of expression, as it has happened within the jurisprudence of the European Court of Human Rights, we saw this topic being addressed through other facets of rule of law and judicial independence. All major aspects of national institutional judicial organization have been subject to review by the Court of Justice. From composition of judicial councils, judicial disciplinary bodies, judicial appointments, judicial liability regime, judicial salaries, independence of public prosecutor, and including also freedom of expression of judges and defamation of judges. Some of the main key questions addressed by the book are: what are the risks of leaving more freedom of expression to legal professionals? And what are the advantages, actually, of exploring new means to defend this fundamental EU value? And I think this particular question is addressed also by Jara's chapter from the Polish perspective, and because he's addressing he's raising a dilemma, the extent to which or how freedom of expression of judges should take form, and that in certain cases also this can be abused, particularly when we're using social media. So there should be a carefulness and a code of ethics also for how we're using social media as a means for exercising freedom of expression. Another key question is: what is the role of the two European supranational courts in shaping the European standard of freedom of expression of judges? What has been the contribution of judicial interaction techniques to the development of freedom of expression of judges? How the rule of law crisis has influenced developments regarding freedom of expression, both in national and supranational courts? And how has the digital shift in judicial communication impacted the exercise of freedom of expression of judges? And there are two themes, overarching themes throughout the book. Of course, the focus on judicial interaction techniques, which is a specific focus also of trial and other previous projects that we have carried out at the Center for Judicial Cooperation. What is interesting about this book is that it's not focusing only on the formal, let's say, judicial interaction techniques, meaning those that are expressly set out in a legislative provision, such as consistent interpretation, preliminary reference procedure, disapplication of national law, and principle of proportionality, but also other forms of interaction, such as through social media, through networks. So these informal types of judicial interaction. And secondly, to identify and address the challenges in using judicial interaction techniques to actually address the rule of law issues. And this is a key topic addressed in two of the chapters of the book that are concentrating on Romania and Hungary, because there have been more and more challenges and barriers to national judges in using and resorting to judicial interaction techniques coming out from European legislation. The book has a comparative approach in the sense that it looks at the jurisprudence of the European supranational court, but it also looks at selected national jurisdictions, that is Italy, Hungary, Poland, and Romania. We initially also had two other jurisdictions included, that is Spain and Slovenia. But these chapters have now appeared in the form of papers published in the European Constitutional Law Review, and they are in open access. So if Mohor has not already sent the links for these two papers, I would kindly invite him to also send them, because I think they're quite enriching and informative as well. And as mentioned by Federica, actually the book tries to summarize the discussion and results we had in the previous project trial, at least the line that we had dedicated to freedom of expression of judges, and more of this project and the outcomes can be found at the links that I have in the slide. And now I'll just briefly go through the chapters, so the structure of the book. We've divided the book in two parts. One is looking at the judicial standards emerging from European courts and jurisprudence. And we have an introductory chapter written by the editors, followed by an insightful chapter written by Zitke Dzicka. I'm sorry if I'm not pronouncing it correctly, Zitke, your family name. And I think she will probably already say a few things about this chapter in her presentation today. She's looking with a critical eye at the case law of the European Court of Human Rights on Article 10 of the Convention. The third chapter is written by Mohor, and it's called Chilling Effect of Limiting Freedom of Expression of Judges. So this is also a chapter that is having in mind this negative impact of disciplinary sanctions on freedom of expression. Part 2 is called Lessons from Europe, and it focuses on national perspective, but they are not purely national, because of course they're discussing the impact of European jurisprudence as well. The fourth chapter is entitled Speech is Silver, is Silence Golden, and written by Raluca Bercea, and is focusing on the Romanian situation. The fifth chapter is written by my colleague Federica, and is focusing on the exercise of freedom of expression in Italy. And it's interesting to understand and to see that actually some of the challenges that judges face in balancing freedom of expression and the protection of judicial independence and impartiality are not national specific, or at least not only specific to Central and Eastern Europe, but we see similarities in regard to ethical questions, also in Western Europe, and we have here the example of Italy. The sixth chapter is looking at judges' presence on social media in Poland. Is a very interesting chapter because it's raising also the issues of when can actually freedom of expression by judges be abused, or how to actually exercise freedom of expression in social media, at the same time contributing to the protection of the rule of law, but at the same time also being ethical in the expressions online. And the last chapter is focusing on the Hungarian jurisprudence, and it's written by Gabor Halmai and Agnes Kovács. And also this chapter is extremely useful and interesting because it shows how, although in Europe the protection of freedom of expression is done in similar wording or in similar constitutional phrasing, de facto the exercise of freedom of expression takes different manifestation, which can be explained by not just legal factors, but there are also social legal factors that can explain these variances. And to conclude, we invited one of the judges that have taken a prominent role in the rule of law and the refugee crisis. The asylum or migration field has been a very difficult and politically sensitive topic where freedom of expression of judges has taken a very negative turn, and I think in Italy it is even more present, where we see the social media attacking, or at least representative of governments attacking directly certain judges who give precedence to human rights protection instead of policies by the government. And this chapter will take a critical look at what has been said in previous chapters, but also connecting it with future developments on freedom of expression. So to conclude, just some key findings from the book chapters. One of the recurrent theme is that of the paradigm shift in conceptualizing freedom of expression from a right to a duty. The use or the perception of preliminary reference procedure as a manifestation of freedom of expression of judges, which comes out especially from Romanian jurisprudence. A stricter supervision of disciplinary proceedings, particularly when they can negatively impact the exercise of freedom of expression. The importance of going beyond legal analysis and looking at social legal factors that can explain the variances in the exercise of freedom of expression of judges. And lastly, this idea of dangerous, or like the danger of abusing freedom of expression within the social media, particularly because I think the social media is a context where people feel more freely in their expressions. So I kindly invite all of you to follow us on the Center for Judicial Cooperation webpage, because we will publish when the news when the book is out. We hope that some of the chapters will be in open access, or at least with reserved access. And thank you again for your attention.